Today, I'm going to answer a question that many clients forget to ask because they're too excited about getting a new condo in Florida or a timeshare in Las Vegas, or maybe even a mobile home in Tennessee. What does acquiring these assets have to do with my estate plan and making sure that it actually works? I'm estate planning attorney Sean Eystone, and without fail, like clockwork, every year when it starts to warm up, clients will reach out to me to brag that they've sprouted wings and become snowbirds over the winter and have acquired these types of assets. And for those who do reach out, we can talk about how updating their estate plan to include a trust that has provisions for those particular assets in those particular states is going to save their time and money and also their family time and money. But usually what happens is the families contact me after these folks pass away and nothing has been done. And there's a huge mess and there might be one or two or three other states involved. If you own real estate or other assets in another state or country, your estate planning is going to become a little bit more complicated. Usually it makes sense to have a trust-based plan to avoid probate in these other states. Because if you remember, probate is just instructions to the probate court about whatever I own in this state, give to these people after I die. Now, a trust, on the other hand, can operate out of your home state and just direct that assets in other states be managed without getting those courts involved. So your trust would simply say, hey, these assets that I own in whatever state it may be, Florida, Nevada, whatever it may be, trustee, you're authorized to take care of those assets if I become incapacitated or if I pass away. So using a trust is usually the best thing to do for these assets to avoid having a probate in a different state, which also would have another attorney in another estate, another expense in another state, and more travel to the other state. So making sure you have a trust in place is usually the best thing to do. However, having a trust-based estate plan is often not enough because there's that one extra step that you have to take each time you get a new asset, and that is to make sure that the asset is aligned with the trust. So a trust is a separate entity from yourself, much like a nonprofit is a separate entity from its donors. Now, a nonprofit has a charitable purpose, but unless it has assets, it can't carry out that charitable purpose. So your trust is like that too. You've given your trustee instructions for these assets in other states, but if you don't actually put those assets from the other states into the trust or make sure that they get there by the time you die, your trustee can't carry out those actions without going into a probate situation. And again, you don't want to have a probate in different countries or states because that just makes things more expensive and complicated for your family and for your trustee. If you thought owning assets in another state was complicated, try buying property in another country. Many of our clients will pick up a condo or timeshare down in Costa Rica or in Mexico without realizing that these assets are now governed by the Spanish Civil Code. Other clients will pick up assets that are governed by the French Civil Code. Now, each of these civil codes has different provisions than what you'd find in your typical United States probate. They typically require that specific percentages must be given to your spouse, your children, or children in the half-blood. So you have to be very careful how you get those assets to your beneficiaries to make sure that they actually get to them. Now, it often requires that we work with a local attorney in the area who understands the law to make sure that you comply with the local law. While most of these laws do enable trusts to own the property to get around these civil codes, some do not. So it's important that we coordinate with local counsel on that. And additionally, we want to make sure that the assets get into the trust in the right way because the IRS has another gotcha in the form of a foreign investment trust tax. So if you don't have the right provisions in your trust will be treated as though it's a separate foreign entity and will be taxed as such instead of it being taxed as though it's you and it's just you that's doing this like you would do in the United States. So make sure before you transfer anything into a trust that it actually has the language in it for avoiding the foreign investment trust provisions. Another time multi-state estate planning issues come up are when clients or their loved ones move to a different state. It's very difficult for people to find the right fit with the lawyer, and having that on top of everything else when you move can be quite complicated. So what we have done over the past 20 years is developed relationships with attorneys in most of the other 50 states. And in that process, we have become local counsel for those lawyers in Michigan. So this allows us to co-counsel with local attorneys in all of the 50 states, and we can work with them and with you or your loved one to have the same quality of service that you've come to expect from us, but working locally with a local attorney to make sure all of those laws are followed as well. Because when you move to another state or your loved one moves to another state, you still want to make sure that your estate plan actually works. So if you have property in another state, or you or a loved one is moving to another state and wants to make sure that your estate plan actually works, give us a call and schedule a strategy session with one of our attorneys by calling the number below, and we can help make sure that your estate plan actually works, even in other states or countries.